Made to the lordship, about to mention for listing of the first appeal against order, my lord, day after tomorrow, my lord. Injunction matter, my lord. Oblige your lordship.
Beg your lordship, with the consent of others, lordship, I beg to mention item number 53, lordship. Learned Senior Counsel, Mr. Insom, today he is out of station, lordship. Matter may be passed over for the day, lordship.
Item number,
Item 53, stay matter, lordship.
who is out of station?
Learned Senior Mr. Isi Sharma. I am for the respondent.
Any objection?
No, my.
The learned counsel for the respondent seeks adjournment, respondent seeks adjournment in this case on the ground that the senior counsel, Mr. A.C. Sharma, appearing in the matter, is out of station. Respondent 1 and 2. Since the prayer is made with the consent of Mr. T. Islam, learned counsel for the petitioner, the same stands allowed. This matter be discussed again after a week.
There is interim order.
Interim after 2 weeks, interim order passed by the.
Your lordship, I beg to mention item number 45 on the daily list. I'm the counsel for the respondent, and we had forwarded an offer, a one-time settlement offer to the bank, which is still under consideration. I've obtained consent from the counsel for the petitioner, and we would request that the matter be adjourned.
Adjourned for how long?
Till the first week of December, your lordship, because the lead counsel for the respondent is out of the country.
Your name, please.
Maitri Das.
On the pair of Miss Maitri Das, Learned counsel for the respondent made with the consent of the petitioner. This matter stands adjourned for 4 weeks. List again in the first week of December. 47.
Your lordship, item number 30 and 31. Item number 30 and 31. 30 with 31. Your lordship, learned counsel, Mr. PP Das is out of station, your honor. The matter may be adjourned for today.
30 and 31 adjourned on the request of learned counsel for the appellate, made with the consent of the opposite party. These matters stand adjourned on the request of learned counsel for the appellate, made with the consent of the opposite party.
After 1 week, your honor.
Adjourned for 2 weeks.
Highly object, your lordship.
My pleasure, lordship. Lordship, I will beg to mention item 55. Your lordship, this transfer petition has become infructuous as the matrimonial suit thought to be transferred has been disposed of.
This matter has become infructuous.
Yes, this matter is disposed of on withdrawal. This transfer petition. Infructuous.
Your name, please.
Alok Das.
Huh?
Alok Das.
Can you speak a little louder?
Alok Das, your lordship.
Alok Das.
Yes.
You are in the transfer petition 28 of 2022.
No, sir. Item 55.
Huh?
Item 55.
What are you saying? I can't understand.
Item 55. Yes, ma'am. Transfer petition 28 of 2022.
This has become infructuous.
Yes, sir.
Why?
It has already been disposed of.
Mr. Alok Das, learned counsel for the petitioner, submits that the main matter has already been disposed of by the court below, and therefore this transfer petition has become infructuous. Full stop. Taking note of the submission of Mr. Das, this matter stands closed as infructuous.
Bless you, lordship.
May it please your lordship. Lordship, I beg to mention for listing a review petition. If for listing a review petition filed on 2010-2020, lordship.
Next week.
Lordship.
Yes.
The lordship. My lord, the transfer petition filed by the wife, my lord. The respondent number 2 is the husband, my lord. He filed a reverse suit before the district judge Karimganj, my
Why the
lord.
sound is not coming? What is the problem? I also have no clue.
May I have the lordship? My lord,
I hear some sound. Huh? No, full rate of me. What is this sound coming from here? Is it vulnerable? Yes,
That is your lordship. But petitioner before lordship is the wife of respondent, petition number, the respondent number one below. Then the sixth below respondent number one husband has filed.
good afternoon. There's something wrong with the sound system. Yes, petitioner is the wife.
Yeah, if the respondent, husband has filed divorce suit, before the district surrender is, and, whereas the petitioner, the present, the grounds for taking transfer, I am stating in page 6, ground number 1, 2, 3.
her marriage has taken place at Dibrugarh, and it was registered under Special Marriage Act at Dibrugarh. The birth certificate of the child is, my lord, page number,
Husband and wife in which place?
my lord,
First resided as husband and wife in which place?
at Dibrugarh.
Heard Mr. A. Royal and counsel for the petitioner. Peruse the averments made in the transfer petition. Full stop. Mr. Royal submits that petitioner and the respondent resided as husband and as wife and husband. Last resided as wife and husband in Dibrugarh. Notwithstanding, full stop, notwithstanding the same, the connected proceeding being FC bracket civil bracket code number 919/2022 has been instituted by the respondent bracket husband bracket close under section 22 of the Special Marriage Act 1954, praying for decree of restitution of conjugal rights before the this is restitution of conjugal rights
But the wife is having 7-month-old child, my lord, newly born child.
at before the court of principal judge, family court number 2 at Kamrup bracket M, Guwahati. Mr. Roy submits that the petitioner is having a 7-month-old child, and under the circumstances, it will not be possible for her to come to Guwahati to contest the aforesaid proceeding on each date. After hearing the submission of petitioner's counsel, I am of the view that come to Guwahati to contest the proceeding on each date. Hence, this petition for transfer of the proceeding to a competent court at Dibrugarh. After hearing the submission of counsel for the petitioner, I am of the view that the matter calls for further examination. Issue notice of motion returnable on 7/12/2022. This is the next date.
My lord, on 14th, my lord, this month 14th. My lord, the baby needs to every 2 hours interval feeding, breastfeeding, my lord, so she can not.
Petitioner to take steps for services noted upon the respondent by registered post with AD as well as legal process within 3 days from today. Hard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby ordered that further proceeding in connection with so and so case remain suspended till the return of the dates.
Obliged.
May I please address? In this case, your lordship, petitioner's claim petition rejected by the motor vehicle claim member here, motor vehicle claims a forfeiture.
For an appeal, this order is appealable.
No, your lordship, earlier I have filed appeal because no order has been passed, your lordship. Only technical ground it is dismissed. No award, neither rejected nor your lordship or not made. Because earlier,
What is, where is the order?
page 10, your lordship. Only limitation ground is.
You see, will issue notice, but your client will suffer.
No, your lordship, page 12, your lordship.
Your client will suffer, I'll tell you why. I'm issuing notice, but because of your obstinacy, your client will suffer. Even if a matter is disposed of on the ground of limitation, it is a dismissal of the main proceeding. The remedy lies in preferring an appeal.
No, your lordship.
Put it in order, someday after 2 years, when the matter comes up, on that ground, you will be asked to file an appeal.
I file appeal, your lordship. Page 12 is the order in this court. Page 12, your lordship.
Hmm.
So, court is not inclined that we have to this petition and file it carefully.
But is it not an appealable order?
No, you're right. I file an appeal, court is not inclined to admit that it should be CRP, that we have withdrawn and filed. And already this issue already decided by this court. I have asked in the order in this court, I handed over to master. I have handed over one order. 6/11/13 relevant paragraph. This court has settled this, Your Lordship, decided this issue, same issue. Already is settled. Paragraph 6, 11, 13, and 13 also directed the registry to circulate the same issue as per new amendment on technical ground. Same tribunal, same. It is not here. It is.
This judgment is on whether the limitations will apply or not. But I am asking you whether once it is held that the petition is not maintainable, the matter is put at rest. What happens if a proceeding is finally either allowed or rejected by the claims tribunal? The remedy lies in an appeal or a revision. Huh? Then why are you filing? You have withdrawn the matter earlier.
I have filed appeal. Amicable, I have initial filed this to a by order.
Why did you withdraw it?
There is no order is passed, only limitation period it is rejected. My case also rejected limitation period as per Amendment Act. If we have filed within 6 months, we have to file. But we have filed within, before amendment, we have filed here. Our petition is filed on 26/8/2019 and amendment coming before 1/9/2019.
Oh, you are again stuck up in the merit of the matter. Whether the application has been rightly rejected or wrongly rejected is another matter. but assuming that it has been rightly rejected or wrongly rejected. In a revision petition, it cannot be corrected. This is not a revisable order. Anyway, heard Mr. Assistant Learned Counsel for the petitioner. There is the interim order dated 21/10/2019. Issue notice returnable in 6 months. Petitioner takes notes for service of notice of Congress. Instead goes to the within a period of 1 year from
May it please your lordship, my lord. My lord, here the contention raised in this petition, my lord, has been answered by the honorable court in another case, my lord, by the file by the same petitioner and rejected that contention, my lord. My lord, I am passing this order, my lord, for your lordship.
Mr. Das, you don't have a case.
Yes,
But for your satisfaction,
Yes.
you just issue notice. Yes, miss, then I'll dismiss it.
no, my lord, yes, my lord, that may be closed.
Huh?
Because earlier, my lord, same petitioner filed another case, my lord, that said that there is no relief claim against this, my lord. Government responded, although they have been party. So therefore, that was, my
The
lord,
bar is in grant of relief,
Yes.
not in filing of suit.
my lord,
Here the two officials are performer defendants.
proper. This is also. but it's a
Heard
case.
Mr. B.K. Das, learned counsel for the petitioner. This revision petition is directed against the order dated
Is 46, my lord, 1/9/2020.
order dated 1/9/2022. Passed by the learned Munsif Kumar Chahayda in title suit number 09/2022. Rejecting the application filed by the petitioner under order 7/11 CPC. Playing for rejection of the claim on the ground that the suit has been instituted without complying with the requirement of section 80 CPC. Such a prayer was made on account of the fact that the two performer defendants in the suit were government officials. However, taking note of the fact that no relief was paid for in the suit against the two performer defendants, the landed Munsif and rejected the prayer made by the petitioner by the order dated, by the interim order dated 1/9/2020 as the revision petition. During the course of argument, Mr. Das has, in his usual fairness, invited the attention of the court to the judgment and order dated 19/10/2022, passed in CRP bracket IO bracket 241 of 2022, wherein the same issue has been decided by taking a view which is contrary to the case corrected by the petitioner. I also find that no relief was paid for by the plaintiffs against the performer defendant. In such view of the matter, the interim order, in the opinion of this court, does not suffer from any infirmity. In view of the above, this revision petition is to be divided under the according.
Obliged.
Party number is this. Anil Pantati and 16 others. Versus. Upendra Kumar Sekhar.
Obliged.
Yes.
But in this case, I have filed title suit, but opposite party filed one after another case, my lord, application, my lord. So at this case, lordship, may please to issue notice.
What is your case?
Yes,
I
my
have
lord.
not understood anything.
Yes, my lord. My case is that, my lord, interim order passed, my lord.
Hmm.
In their application, my lord, injunction petition, without hearing me, that is only my case. These are
The
the
order has
others.
been passed in their injunction application.
Yes, my lord. In my title suit, they have filed, my lord, injunction application, my lord, by the respondents. Therefore, without hearing me, interim order on the very first day. Subsequently, it is disposed of. When we filed before the civil judge, my lord, Cooperative, my lord, that was also rejected. That is my only case. Without hearing me, how can, my lord?
Who has written the synopsis?
I-
You have written. It is a nightmare for the judge.
Sort the reason.
But Mr. H. the Planet Council. Settles the grounds taken in the original petition. As well as the complete order dated. Which page is that?
36 to 22, my lord. 85.
Huh? Page?
Page 85. 85.
Order dated. 36/2022. Passed by the learned civil judge Bertetta in Miss Appeal number 02/2021. Dismissing the appeal filed by the, dismissing the appeal.
Yes, my lord.
Filed by the petitioner against an order of temporary injunction passed by the learned trial court. Mr. Issue notice returnable in 4 weeks. Petitioner takes steps for service and notice of the respondents by the instruction. Respondents.
All right.
No, it's not okay. That's fine. You sound too faint at our ideas. Disturbance. Yes.
But I am going to blame people in the patent support. I filed an application for amendment under order 14 with 5 million for amendment of the issue. Or repayment the issue. But there. My application is in case 104 million.
Either.
And it's at 30.
No, I would have to kick off 180. This is the first time it is happening. With this sound, I think. Mr. Chaudhary, I can barely hear you.
Yes.
Something is wrong with the sound system. Nothing is wrong with you. It is, problem is with the sound
Yes.
system.
Yes, technical purpose.
Yes, anyway, what is this matter?
Well, I am for the plaintiff in the trial court. But I filed an application on the order 14 rule 5 for amendment or reframing of the issue. My application is at the page 104 and it's at 30.
Page 124.
104.
Yes.
This application was filed, the second issue is most relevant, there is subsequent event in the suit, after filing of evidence on appeal. Because in 2019, defendant number 1 died and the 2 defendants were substituted for
Where
the
is the impugned order?
impugned order. Their space under the 108 and it's a 14. Our learned counsel for both sides. And petition number 247/2022 under order 14/5 before the chief right. Who is the learned counsel for the plaintiff for amendment of the issue named in the suit. The learned counsel for the defendants had objected to this claim, stating that the suit is old one and framing of additional issues and any amendment in the issue may linger more issues. That is the ground that should linger under there because of that kind of there.
What is the stage of the suit?
Is my lord, now the defendant's evidence, my lord, at the stage of defendant's evidence. My lord, it is absurd, my lord, in this case, my lord, that the substituted defendant, they have been allowed to file written statement come counter claim. And the matter has become complex.
But now at this stage, what can be done?
My lord,
If a new issue is framed, then the plaintiff must get a chance to adduce evidence.
yes, my lord.
How can that be? You are for the plaintiff.
I am for the plaintiff. Since because my lord, in 2019, defendant number 1 died, and in place of him, his representative, 2 representatives have been added as additional defendants number 1 and 2. And they have been allowed to file written statement and counterclaim. It is absurd, my lord. At that stage, my
No, no,
lord,
but that is another matter. You are before the court on the ground that additional issue was not framed.
because of that additional issues that have been particular to it, because they have claimed their own position.
No, that is another matter. Once the trial has gone halfway through, framing of new issue means you have to start from the beginning.
Malad, the whole matter has been, the complex.
Mr. Chaudhary,
Complex that has arisen, only.
these are things which are bringing a bad name to the civil court procedure.
Malad, the written statement.
You have
and
missed the bus. Your clients have missed the bus. We can't-
Written statement and counter claim that has been allowed, to the substituted
Then
defendant.
you should have challenged that order.
Yeah,
That order has not been challenged.
that order has not been
So
changed.
you challenge that order, withdraw this, challenge that order. But then
But,
also, see, it can't go on like this. At an appropriate time, appropriate challenge made, the court will look at.
Malad, since because the defendants, new defendants have been allowed.
Mr. Chaudhary, I agree with you, but you have accepted that order. New defendants have been allowed to
Suppose-
file written statement. That order has not been challenged.
But the fact is that has been, new facts has come, my lord, in the suit, my lord.
In private,
If issue is not.
this
my
is
lord,
a private law litigation. If you waive your right, it's okay. Anything can be done. At that time, you means your client. At that time, if an objection was raised, issue was challenged, that was the appropriate time. Now, at this point of time, how the court can reverse it?
In the suit, my lord, they have created new facts, my lord. That is why, my lord, issues that.
No, but
that is
now at
required-
this stage,
That is required, my lord.
you are only
Other-
asking.
Otherwise,
court
we will
to-
suffer, my lord, the entire suit will go against us, my lord, if this issue is not framed. my lord.
It will not go against us.
This is regarding possession, that suit is for possession only.
No, these are things we cannot allow anymore because in civil court, people are losing faith on the civil court proceedings. Anything is happening someday, suddenly somebody wakes up and comes to the court asking for this. Today, if your prayer is allowed, this trial of the suit has to go back from the plaintiff's evidence. How it can be done?
Only in respect of possession, my lord. The other aspect, my lord, that has been dealt with, my lord. The issues framed earlier, my lord, these are not sufficient, my lord. Because of the subsequent written statement, my lord.
I'm not convinced, Mr. Chaudhary. This is too late in the day. Framing of issue would require retrial. I will not permit retrial of this.
If certain facts have been added, my lord, after the.
That's right, but you should have challenged those. When the facts were introduced by amendment, you should have challenged that order.
We have submitted our written statement, my lord.
You challenged that order.
We have
even now.
submitted our written statement. But these grounds will come in the appeal, my lord, we do not challenge here, my lord. But regard so far the issue is concerned, my lord, is a.
No, it will come. Your client will have to suffer. Because the purity of the proceeding has to be upheld. Counsel did not advise, so can't help it. Can't help it. Otherwise, anybody will come at any stage and ask for any order. How can it be done?
Let it come in the next week, my lord. In the meantime, I will take instruction from my lord.
On the prayer of Mr. D. Chaudhary, Learned Counsel for the petitioner, this matter stands adjourned for a week.
For admission, item 6.
The petitioner, he was working as a record keeper in the establishment of the industrial tribunal in South. She was appointed in the year 1981 and her initial post was sanctioned as a record keeper and at that time industrial tribunal was under the labor department. And she has been working in 2010, the industrial tribunal, labor board, and I think all has come under the control of the judicial department. Therefore, the City Commission has recommended separate pay scale for the record keeper and the record enjoyment. That is, I point out my note. That's my note. And actually page 29, there's been a common category post, the supervisory assistant, UD assistant, judicial cashier.
Yes, you have filed your affidavit.
Yes, my lord, I have filed.
Any reply to the file?
Yes, I have filed it.
Then we'll post it for hearing.
Lordship, can be.
Post it for hearing.
Earlier, my lord, the petitioner has made requisition the Honorable High Court for the presiding officer. High Court has written with the government for taking step for payment of the record keeper. But now they are filing the affidavit opposing the petition. And so the High Court correspondence with the government, my lord. It is in the page 59, my lord.
So we'll hear the matter finally and dispose of. Pleadings are complete.
Leading sir.
Pleadings are complete.
Yes.
We'll hear and dispose of the matter.
There is very disposal the admission stage because the almost major part is hard by the earlier court, my lord. They are directed to produce the copy of the City Commission report.
Some court has heard this matter already.
Not, my lord, in entirety, my lord, some, my lord, facts are, my lord, ascertained. Thereafter, I was directed that you produce the copy of the Shetty Commission's original report. Extracts are there in the affidavit file, my lord.
Last for the, my lord, 31.
It was before the court of Honorable Justice Sekia.
So if the honorable judge has already heard the matter, it will be easier. Heard Mr. K. Sharma, our counsel for the petitioner, as well as Mr. H. Das, H. K. Das, Lanet, standing counsel, GHC, appearing for the official respondents. Full stop. It is submitted at the bar that this matter has been substantially heard by a coordinate bench headed by Honorable Mr. Justice Soumitra Sekia, and therefore Sumit Sekhar, full stop. Since pleadings have already been exchanged and the matter is ready for disposal, hence a request has been made at the bar to post the matter before the appropriate bench. The registry to take note of the above and list the matter after 2 weeks before the appropriate bench.
That may be fixed, my lord. That may be fixed, my lord.
After 2 weeks, after 2 weeks,
Petitioner by the.
after 2 weeks.
Much obliged.
May it please your lordship. My lord, regular first appeal against judgment and decree passed by the honorable civil judge to Kamrup Metro. Impugned judgment and decree is at page 31.
It's a regular first step.
Regular first.
This RFA has been referred against the judgment dated 12/9/2022 and decree dated 14/9/2022 passed by the London Civil Judge number 2, Kamrup bracket M, at Guwahati, entitled suit number 37 of 2016. Dismissing the suit.
Dismissing this.
Dismissing the suit filed by the appellant as plaintiff. Heard Mr. D. Chakravarti, learned counsel for the appellant, admit the appeal, issue notice upon the respondents returnable in 6 weeks, call for the LCR, steps by registered post with AD, call for the LCR.
Deeply obliged.
Lordship, this is also a regular appeal, Lordship, against the railway claims tribunal. Lordship will admit it and
Heard
call for
Mr. D.
the.
Chakravarti, learned counsel for the appellant, this appeal is directed against the judgment and order dated 16/6/2022, passed by the learned Railway Claims Tribunal, Guwahati bench in connection with OA number 13-59 of 2012. Admit the appeal, call for the LCR, issue notice upon the respondent returnable in 6 weeks. Appellant to take steps for submission notice by registered post.
Lordship, in this case, the petitioner is the wife and the respondent between the lordship. And lordship, I think,
Finding it very difficult, it's rarely or audible. Who is for the other side here?
none are a lordship. Now, lordship, there is the amicable settlement lordship.
Yes,
Lordship, actually, this, and file this criminal petition, lordship, being before the.
this is to be disposed of.
Lordship,
Today will not be possible. I can't, with this audibility, I
lordship,
can't.
lordship.
When do you want it?
Lordship, it's on fourth lordship, one that was case is standing before the district judge of Tribunal lordship, before that lordship,
On
fourth lordship. Fourth lordship,
4th of November.
lordship. Because already actually we have filed additional affidavit, you can other side also file. one additional
Why before 4th of November?
Because the lordship, because there's the amicable settlement, they have filed on joint petition.
There is a,
Amicable settlement lordship between both their husband and wife lordship. And lordship, already there is a case of divorce lordship before the district judge of Tribunal lordships. And now lordship, they want to withdraw all the cases lordship. There is totally 13 cases between both husband and wife lordship. And they want to withdraw all the cases, if all the cases are withdrawn, then only they get the degree of divorce lordship.
do one thing. You call them to fix it. I can't continue it. Let them fix this sound. I can't hear anything. हमने do soft please, make a noise. It is a problem where I can find. Okay, keep coming for all right, I'll just rise for 10-15 minutes. Let them fix it.
I'm for the respondent number 2, Milord.
Lordship, already there is amicable settlement, lordship. And in this regard, I have filed my additional affidavit, lordship. And one case is pending before the lordship, Dibrugarh district judge lordship, the divorce case lordship. And the 4th was the date lordship fixed for their mutual divorce lordship. So this is the, actually, lordship, I filed this criminal petition paying for the quashing of recall of the order of this honorable court lordship. So on the earlier occasion, it was listed before some other court lordship and lordship.
No, Milord, Milord, may I place the case, Milord? So what has happened, Milord, here, earlier, Milord, I had come to this court, Milord, by way of, Milord, criminal petition 5/22/2018, Milord. So for quashing of an order, Milord, for the, of a complaint case. The probably sound is echoing, Milord.
Echoing lordship. Sound.
Probably with one speaker, Milord. We are hearing you, my lord. We are hearing you. So, my lord, the complaint case under 406 was filed. We approached this court for quashing of the Miller complaint case. My lord. And my lord, in the process, my lord, there was a settlement, and in fact, my lord, the respondent number 2, the husband and wife. The wife filed an affidavit before this court, my lord. And on the basis of this affidavit, my lord, the lordship was passed to pass this order 29/3/2019, my lord. And the my lord, order was served. My lord, thereafter, there again differences came up. My lord, ultimately, my lord, they filed an application, my lord, stating that the affidavit which was filed before this court, my lord, was not signed by her.
Yes, Lordship.
And in fact, my lord, on the basis of that, my lord, this present petition was filed for recalling of the earlier order.
Lordship.
Now, my lord, the matter has again been settled between the parties. And in fact, my lord, therefore, we have also filed already a divorce application, my lord, which is pending. My lord. Other cases have also been withdrawn. Now, probably, my lord, this case, my lord, we have
Yes,
both filed an affidavit, my lord, stating that the matter has been compromised between the parties. Then, my lord, she will be withdrawing, my lord. That is the case. Yes, yes, my lord. My lord, in fact, we have both have filed
Both
affidavit.
were filed, Lordship, joint petition, Lordship.
Heard Ms. G. Bora, learned counsel for the petitioner, also heard Mr. Appeared for responding number 1. This criminal petition has been filed by the wife with a prayer to recall the order dated 19/3 passed court in another criminal petition bearing number 5/2018 system. However, during the pendency of this, the entire dispute by and between the petitioner and the respondent number 2, that is the husband and wife, has been amicably resolved. The same fact has also been brought on record, filing affidavit by the petitioner as well as the respondent number 2 by filing their respective affidavit. System. The learned counsel for both the parties submits that out of the stand of the parties as projected in the affidavits, this matter be closed. The above, nothing suffices for decision in this criminal petition, and the same is accordingly
Deeply obliged.
Deeply.
connected. IA, there is some IA.
No, I is there, Lordship. No, I is there, Lordship.
May I please, Your Honor? Your Honor, this appeal is filed for enhancement of award passed by the MACT 1, Kamrup Metro, Guwahati. The notice may be issued and requisition may be
Yes.
issued for call for LCR. Your Honor.
Heard Miss
Lee Chaudhary.
Referring to the appeal. The appeal is directed against the judgment and order dated 27/6/2022 by the learned member, motor accident claims tribunal number 1, Kamrup (M), Guwahati. MSC case number 2826 of 2015. The appellants are seeking enhancement of the amount awarded by the learned tribunal. I have perused the grounds taken in the stop issue notice returnable in 6 weeks with appellants to take steps for service of notice upon the respondents by registered post with AD as well as legal process. Call for the LCR.
Obliged, Your Honor.
May I please come? My lord, this is against an rejection of the prayer made for my lord maintaining status quo with regard to the bank guarantees given in pursuance to a tender. When we had filed a section 9 application before the honorable court below, the interim order was passed in June. Thereafter, my lord, the tender was terminated. Thereafter, and they my lord, in the already that status quo was there, the court then considered they filed their affidavit, considered the matter. And my lord said that nothing doing, the bank guarantees are permitted to be revoked. One, there are two bank guarantees, one performance guarantee.
Guarantees are permitted to be revoked.
No, my lord, invoked means invoked. What had happened is in the terminate, what exactly is it with regard to this water supply project, my lord? It's an old project, line from 2009, it's there. 2009 till 2018. From 2018, my lord, we had started distributing water. But the payments were held up, my lord. There was discussions all along.
Water where?
In South Guwahati, in western part of South Guwahati project, madam. Maligaon, that Jalukbari, Maligaon, that area, madam. Water is being supplied, the payments were not being made. On 1/9/2021, there was a discussion between the GMDA in presence of the minister. Therein, my lord, an understanding was arrived at that the payments would be cleared to the extent possible, and the GMDA would give us an amount of 9 crores. Out of which we will now then we assured the GMD, if 9 crores is paid, we will give them, we'll buy projects for material for around 12 crores and then proceed with the work. But this did not happen, my lord. 7.7 crores were paid, but my lord, we had, because the government itself, my lord, there was some understanding, some contractors' dues were there, we had to pay, suppliers' demands were there, and all of a sudden this was done. We, my lord, instituted an arbitration application under 11.6. Both parties now have agreed to proceed for arbitration. The only thing, my lord, the names of the arbitrator was to be proposed. It should have been done today. Unfortunately, my lord, the court is not there today. So, my lord, the matter got adjourned. Now, 17.58 crores, 48 crores, my lord, the invocation is for now presently is for the performance guarantee of 17.48 crores. And we have a due receivable of around 20 plus, my lord, and the total would be around, our claim is around 1 crore 31 lakhs. Total 132, 1.31 crores. 131 crores. 131 crores, my lord. In that view of the matter, my lord, the arbitration will happen in a very short time. If your lordship can protect us till that time, thereafter, my lord, we can approach the arbitral tribunal under section 17 and then, my lord, proceed with the matter.
Protect means in what?
That status quo with regard to invocation of the bank guarantee, my lord. 17.48 crores, my lord. Because of the facts and circumstances involved here, my lord. And these
Mr. Nair, the law on this subject is very well.
I understood, my lord. It said that unless prejudice is shown. My lord, why my case is that even the termination order will see, my lord will see, there is a reference to an agreement of 11/9/2021. Wherein, my lord, the agreement is that they will pay us 9 crores and we will buy 12 crores. Admittedly, 9 crores was never paid. My lord. There was discussion.
No. Mr. Nair,
Lordship.
please respond to this.
Lordship.
Whatever your claims and their claims, counterclaims on merit is another matter.
Lordship.
It stands on a different footing.
Lordship.
But the judgments which are now available in public domain focuses on one aspect when it comes to bank guarantees. That it's a automatic vehicle which comes into play the moment the employer seeks invocation. And the jurisdiction of the court to interdict is very, very limited.
Limited.
That is when there is an allegation of fraud.
One. And
Something-
prejudice.
Prejudice will be there in every case.
And that's what
Nobody
Supreme
will
Court said.
say that, all right, I invoke the bank guarantee.
No.
Right.
Lordship.
So whether you have a good case, bad case, that's another matter.
Lordship.
But what is the point in giving a bank guarantee? If in every case, the party comes to the court and says, injunct it.
My lord, my case before my lord.
In fact, 1994, 1 SSC 1 is the Magna Carta on this.
Lordship, and that has been followed subsequently in 1990, and the learned court below has also relied on a judgment, my lord, of 1997, that State Sugar Corporation, 1 SSC 568, wherein, my lord, it said second exception to the cases where allowing encashment of an unconditional bank guarantee would result in irretrievable harm or injustice to one of the parties. Now, here my case would be, my lord, to just bring it. I know it's difficult, but to just bring it within that narrow campus. My lord, on 1-9, if my lord sees the minutes, there was a clear understanding that they will pay us our dues. There was a huge amount of dues pending. And then the subsequent agreement on 11-9 saying that they will release 9 crores, we will get 12 crores. Neither of this were fulfilled, my lord. If my lord can have that agreement, minutes of the discussion, at page 280, my lord. And 95% work was completed and the water was being supplied, my lord.
Page 284.
280, my lord.
Yes.
My lord, see, this is serial number 2, my lord. GMDA will pay the contractor all such amounts presently due and certified. All future payments will be duly certified by the PMC and payments released by GMDA within the 7 days of receipt of certified bills from the PMC. Same from its own resources or from the fund available in the capital expenditure head. The fund paid by GMC to so-and-so will be recouped from the fund sanctioned by the central government. Then, my lord, escrow account and all, and the agreement, my lord, would find at page 266, my lord. If my lord have 266, the last whereas, my lord, and whereas certain issues developed towards slow progress of works and payments, which both parties resolved by mutual discussion on 1/9/2021 on mutually agreed terms. Hereinafter appearing, both parties have agreed to the terms and hereby mutually agree to abide by the following terms as mutually agreed between them and hereinafter appearing. So, my lord, they are admitting that the slow progress was because of non-release of funds. And then, my lord, page 267, they say, my lord, first party will make payment of rupees 9 crores to the second party to defray outstanding, upon receipt of which the second party will purchase material worth 12 crores within a period of 60 days. The second party, upon receipt of payment of 9 crores, will complete the work by May 22. And, my lord, it's on record. 7.7 was given, which we, my lord, adjusted with our suppliers. And the balance was never released. And in spite of this position, my lord, they have now proceeded and terminated the contract on 6/8/2022. And therein they refer to this, particularly to this agreement. My lord. If lordship can have that termination order, page 203 and 204. My lord. Page 203, my lord, 4th paragraph. My lord. As a measure of conciliation, a supplementary agreement was executed by and between the contractor and GMD on 11/9/2021, which novated certain terms and conditions of the contract, under which you were required to maintain progress of the work in accordance with the schedule annexed to the supplementary agreement to expedite the completion of the scope of work under the contract. Under the supplementary agreement, an amount of rupees 7,70,000, 7 crores 70 lakhs was already disbursed by GMDA against the demand for so-and-so submitted by. So they also admit, my lord, that 9 crores never came to me. And that amount of 9 crores was to defray my pending payments. So naturally, my lord, I could not clear up the bills. So the things did not come to me. And this was being discussed all around. And till now, the bills have not been paid. So my receivables, my lord, it has fallen from your lordship. That's the actual position of law. Now, even if this is taken away from me, my lord, everything is now with them. And this is also good. I'll be left with nothing. The arbitration is just, it will be, my lord, the board would be constituted anyway. Moment the bench is there, the board would be constituted.
Bench means which bench?
My lord, bench court number 2, my lord. Because on the last occasion, the parties agreed. If your lordship can have page 26, the last order. my lord, last line, page 26. 26/10/22 order. It has been submitted at the bar that the parties would have agreed to proceed for arbitration. However, they sought some time to propose the name of the arbitrator by consensus of both parties.
So you have agreed on some
So,
arbitration.
but that's what I've been instructed. Well, some arbitrators' names have been agreed upon, my lord. So that will be placed and the arbitral tribunal would come into effect. Till that time, my lord. My lord will protect me. I'm only praying for that, my lord. And they have now sent that letter to the bank, my lord, yesterday night. I have 24 hours to till tonight, my lord, I have the time. One have been in 17.4 crores, which is the performance guarantee.
There has been invoked.
No, that the letters have gone to the bank. 24 hours is there, my lord. By tonight, the bank would be clearing it, my lord. They have sent this letter on 31/10. Received yesterday by the bank, my lord.
As it has already fallen from Lordship's mouth, when the court can interfere in this kind of issues. So I don't find any infirmity in the order which is put to challenge here. The lower court has rightly rejected their prayer. And see, Lordship, my learned friend went up to the 4th paragraph. What about the 5th paragraph of page 203? However, you have once again failed to discharge your material contractual obligations under the contract, read together with the supplementary agreement. The original agreement was of 2009. The project was to be completed in 2016, and Lordship knows the plight of Guwahatians now. Only because of Gammon, only because of their mismanagement, they have received a lot of additional payments also.
No, that is another matter. Today, we'll only strictly confine.
Yeah, unless there is an allegation of fraud,
Hmm.
the honorable court will not, because that is a separate agreement between the banker and the person who has taken the bank guarantee. That is the position. I can quote a judgment of 2008. Law is very clear on this law.
Mr. Nair,
Lordship.
Guwahatians have
it
already
is
suffered
difficult.
much.
You can convince the court if you want to address the court in more details. The reason is as follows. Unfortunately, this court or I had occasions to deal with many of these matters. You see, the bank guarantee mechanism stands in a different footing than the contractual disputes.
Lordship.
It is a supervening guarantee given to the employer, which the employer can just invoke like press of a button,
Lordship.
even on wrong grounds. Even illegally and arbitrarily, it can be invoked,
Done, my lord.
correct?
Lordship.
The only area is when it is fraudulently invoked, which results into an irretrievable or irreparable loss. Then the courts for ends of justice, ex-debitor justice can look into the matter.
Lordship.
From the arguments you have made, your contention is that they have not fulfilled their obligation, as a result of which you could not fulfill your obligation, as a result of which it cannot be held that you are a defaulter. That argument perhaps will not
I'll
come
not go
into.
to that extent, my lord. My only to think that what is the prejudice being caused to me, just to delineate that area, my lord. They have said that I have to receive payments. They said in the discussion that they will pay me. Now, my lord, I was literally
So
bankrupt.
they are acting in an arbitrary manner.
Arbitrary
That
manner,
is also permissible.
permissible.
Yes.
But I'm trying to bring my case within that prejudice thing. I know it's a very slippery ground. But the issue is, my lord, if my lord sees the sequence of events, they have already put me into the back foot, put me behind the wall. Now, by withdrawing this also, my lord, I'll be left nowhere.
That is the idea. That is why you have been asked to
And
give a bank
lordship,
guarantee.
it's not a case that I have not done the work. 95% of the work was completed. And they novated the contract in, my lord, August, in 2021, September. There is a
So
novation of the contract.
Is it a conditional bank guarantee?
No,
Then-
unconditional.
then
I understand. It's an unconditional bank guarantee. And normally that's
we
the
will
bank.
be completely rewriting the jurisprudence on this.
My
Because-
only prayer, my lord, was that till the arbitral tribunal comes into being. I was only praying for that, my lord. Till the arbitral tribunal comes into being, I was asking for a protection, not for a protection beyond that. Under section 17, I'll approach them. To that extent, I was seeking a liberty. I'm not saying, my lord, that my lord will prevent them for all times to come. That will not be invoked. But only till the, my lord, arbitral tribunal is constituted, which would be considered now anytime. My lord will give me a liberty to approach that, and my lord will direct the arbitral tribunal to decide on this first before proceeding for any other matter.
That arbitral tribunal, when it will come, is another matter.
No, it's already on the anvil, my lord. It's coming. I've showed, my lord. We have agreed. Both parties have agreed. If it was not an agreement, then would have
The
been,
letter has already gone. The letter invoking the bank guarantee has already.
has already gone, my lord. That's the problem. My lord. That's the only problem I have for one, my lord, not for the other one. Security deposit that they have not invoked till now. But for the performance guarantee, it has gone.
Can you hold on the security deposit if the court doesn't interdict with the performance guarantee? Can you hold on with the security deposit for about 2 weeks or so?
And the
Mr. Saikia, assuming that in the performance guarantee, the court does not.
Possibly not interfering.
Hmm.
My humble submission,
Let's also be equitable, which the government is also. Well,
the thing is very clear, Lordship, that if suppose that the amount which was agreed to be paid in 2021, he did not raise any objections.
what I am proposing is, the letter which you have written will
Yes.
not interfere with that.
Lordship.
But insofar as the security is concerned, can you hold on for 2 weeks?
Lordship will-
We'll give them 2 weeks time. In the meantime, the arbitral tribunal, etc., whatever.
Lordship.
Huh?
Lordship.
my lord will give us 4 weeks time, 2 weeks more, because my lord, the courts will have also to come, then the letters will go to the arbitrator, come back. It will take some time, my lord, because of the new
Let it be
conditions.
for 2 weeks now, Lordship. If required, Lordship may take it another
Okay.
call after 2
2
weeks.
weeks.
The invocation of bank guarantee for performance guarantee
Performance guarantee
has already been issued.
issued.
What is the amount involved?
It is, my lord, the exact amount is 17 crores 48 lakhs 50,000. It is with the Canara Bank. And the
Canada Bank, which place,
Canara Bank,
branch?
Mumbai, maybe. I'll just give it. It's my lord, Assistant General, no, it will go to Credit Branch now.
Is Cooperative Mumbai, Lord.
Cooperative, Mumbai. Cooperative, my lord will say Canara Bank, stressed asset management, 21.
Is 21.
Yeah, address to. Oh, yes, my lord. Down below, page 21. Cafe Parade, Mumbai, stressed asset management branch.
And what is the,
Security deposit is, my lord, same amount, 17 crores 48 lakhs 50,000. It is with, my lord, Punjab National Bank. Borivali, Bombay. Mumbai.
letter has been issued?
No, security deposit, no letter has been issued till now. It's only with regard to the performance guarantee there.
And where are the particulars of security deposit?
My lord would have the first one, performance guarantee at page 21.
Yes.
It is extended up to 31/12/2022. And the next one, my lord, particulars, my lord, will have it at 23. It is extended till 10/11/22, and we will extend it further. And my lord, that undertaking.
That is the catch, Lordship.
No, we have,
That is the catch.
No, subject to the condition that they.
Ah,
extend it.
my lord, we have extended it.
No, the thing is that it is extended up to 10/11/2022. If he does not do it, because we have seen his track record. He was supposed to complete the project in
That's
2016.
right.
It is not,
Within 3 days from today, they will extend it.
Lordship.
on that, the Lordship will pass that order. My assurance is before this order, we are not going to invoke it. But today is second, let them do it and place the record before this honorable court on scene.
Lordship.
All right, then we have it, day after, on.
It is.
fifth.
My lord will have it on next Wednesday by that time, because the time is there, my lord. Next Wednesday, my lord will have it. In the meantime, I'll get it extended. my lord.
All right, Wednesday,
Monday, let it be Monday, Lord.
Monday morning. My lord.
No, no,
Monday,
Wednesday.
Wednesday. Well, I'll get it extended. Hey, I'll do it on
I
Wednesday.
may not be here, my colleague will.
I'll undertake.
heard Mr. UK Nile, Senior Counsel assisted by Mr. B. Dekar, Learned Counsel. for the appellate, also heard Mr. D. Saikia. You are appearing as Regia Assam.
Yes.
Regia Assam, and Learned Advocate General Assam, assisted by Mr. S. Bora. Yes, fine. Filed under section 37 bracket 1 bracket close bracket B small b bracket close of the Arbitration and Conciliation Act 1996 is directed against the order dated 2022
Miss,
passed by the learned additional district judge number 2 Kamrup bracket M bracket close at Guwahati, refusing to issue an order of interim measure under section 9 of the Act of 1996 on the prayer of the appellant to restrain the respondents from invoking the bank guarantees pertaining to bank guarantee of an amount of rupees 17 crores 48 lakhs 50,000 pertaining to performance guarantee. And another bank guarantee of equal amount on account of security deposit. By referring to the materials available on record, Mr. Nair, Senior Counsel for the appellant, submits that although there was an express undertaking by the department to make available an amount of rupees 9 crores to his client for completing the work, only rupees 7 crores 70 lakhs has been released, as a result of which the appellant could not complete the work, although more than 95% of the work has already been executed. Mr. Nair submits that the respondents have already invoked the bank guarantee pertaining to the performance guarantee, and if the same is acted upon by the bank, then the same would cause irreparable loss and injury to his client. Mr. Nair therefore submits that in order of interim measure under section 9 of the Act of 1996 be passed by this court, restraining the respondents from invoking the bank guarantees. It is also the submission of Mr. Nair that the process of appointment of arbitrator is at an advanced stage, and within the course of this month, there is a strong likelihood that the arbitrator would assume jurisdiction in the matter. Responding to the above, Mr. Saikia submits that the appellant is a clear defaulter, and the said fact has been duly taken note of by the learned court below while rejecting the prayer. As such, from our submits Mr. Saikia, there is no scope of interference with the improved order passed by the learned court below in the present appeal. Mr. Saikia further submits that the letter invoking the bank guarantee for the personal guarantee has already been issued. However, has already been issued, and therefore this court may not interdict with the said process at this point of time, as the appellant has failed to make out any case. After taking note of the facts and circumstances of the case, as well as the submissions advanced at the bar, I am of the view that the matter calls for further examination. However, the appellant has failed to make out any case for this court to restrain the invocation of bank guarantee with regard to the performance guarantee for a sum of rupees 17 crore 48 lakhs 50,000 lying with the Canada Bank, Cafe Parade, CAFE, Cafe Parade branch at Mumbai. The prayer for interim relief therefore stands rejected. Insofar as the bank guarantee pertaining to the security deposit is concerned, Mr. Sekia submits that unless the bank guarantee is extended, the question of protecting the appellant in that matter also does not arise. The learned Advocate General, however, assures this court that in the next day, the bank guarantee for security deposit shall not be invoked by the department. Responding to the above, Mr. Nair seeks posting of this matter again on Wednesday, that is give the date 60.
Could it be on seventh, Lordship?
7th.
That is Monday. We have still 4-5 days.
Okay, ma'am.
On
Why not?
7/11/2022, so as to enable his client to extend the bank guarantee 31st of December 2022. Prayer allowed. Let this matter be listed for admission again on
Sir.
7/11.
Highly
I
obliged.
will excuse my presence on that. My friend would be there.
That's all right. If it is extended, then
Will be lodged.
the order that the court proposes to pass. if
Will,
it is
will.
extended, Will bring it for 2 weeks.
Lodge,
Let the arbitrator take it.
lodge.
Highly obliged.
Much obliged.
Better calls it father.
Please, my lord, I am sorry to say, my lord, the memo of appeal has not provided to the respondent, my lord, in the earlier appeal, my lord. I will start today itself, my lord.
This is come up for admission.
Yes, Lordship.
Mr. K. Parvati, counsel for the applicant, let this matter be listed again in the next week, so as to enable him to furnish a copy of the memorandum of appeal in his P. Butterfly, learned counsel for respond number 1.
My lord. Obliged. May I please your lordship? In the instant case lordships, appeal has already been admitted, but inadvertently no substantial questions of law have been praying. And it was admitted 9/5/2022 lordships. Hence, it has come under order 41 lordship.
Appeal has been admitted without framing any.
Framing subject questions of law lordships.
So what is to be done now?
The subject question of law lordships 1, 2, 3 that may be taken into consideration lordships. The first appellate court without formulating any decisions.
Ground numbers 1, 2.
Don't know 1, 2, and 3 lordships.
Which page?
Page lordships 58 start from appellate court judgment lordships.
No. Ground number 1, 2, and 4 of which page? At which page?
Lordships page 4.
So why don't you give the substantial question of law? Give it in writing. Where are the substantial question of law?
Lordship, thus I have
No.
In
not
appeal,
all.
ma'am.
You have to give substantial question.
separately,
Huh? Yes,
separate,
that's the requirement of the rule.
but I have,
No.
in the memo of appeal lordships, I have stated,
Where are the substantial, is it given in the memo of appeal?
memo of appeal, page 4 lordships.
That is the ground, not your substantial.
There's something questions of law this,
Okay. Which one? 1, 2,
1 and 3 lordships,
1, 2, and 3.
lordships.
All right, we'll make it clear.
Essential question of law.
Ah.
Because here in this case, the plaintiff has challenged with respect to sale deed which was executed in my favor prior
to execution of their sale deed with respect to only one dag number 578. But by this said sale deed, I have purchased 4 dags of lands. And he only challenged the 578 should be, the entire sale deed should be cancelled. And that has been discussed by the, well discussed by the learned lower appellate court, my lord.
That's all right, Mr. Ghosh. See, appeal has been admitted.
My lord, that's why the last occasion, the order has been passed that since it is admitted without substantial question of law, the matter has been placed under order 41, rule 11. That is why this has come for order 41, rule 11 again.
Order 41, rule 11 says what?
Regarding admission of the appeal with substantial question of law under section 100.
So you are saying appeal should be dismissed?
My lord, there is no question of substantial question of law is not there in this case. Because the kindly see whether the finding of the first appellate court is not vitiated in non-compliance of mandatory requirement. This has been discussed. Mandatory requirement has fully discussed.
So Mr. Borvea, you come up with substantial question of law. We'll have it next week. Otherwise, we'll dismiss it. These are not substantial questions of law. You come up with proper substantial question of law and argue the case.
Yes.
Mechanically, orders will not be passed in this court.
Yes.
Let him, how much time you want? 10 days time?
10 days.
Okay. Heard Mr. F.E. Borvea and counsel for the appellant who submits that he be granted further 10 weeks time to formulate substantial questions of law and place the same before this court for consideration of the matter in the light of the order dated 1/8/2022. Mr. S.K. Ghosh, learned counsel for the respondent is present and submits that no substantial question of law arises for a decision in this second appeal. The said aspect of the matter would be examined on the next day. This case accordingly. Please come prepared with a proper substantial question of law. Otherwise, I'll close the matter.
Oblige.
None appears to the appellant on call. From the order dated 5/9/2022, it is seen that the appellant's counsel was absent even on the previous day when he spoke. When this court had observed that the appeal will be dismissed for non-prosecution, if the counsel remains absent even on the next day. However, I find that the name of the appellant's counsel has not been reflected in the cause list today. In view of the above, register to verify and list this matter again after 10 days by reflecting the name of learned counsel for the appellant in the cause list. Yes.
May it please your lordship. My lord, in this case, only appellant died, my lord. And thereafter, my lord, we inform the legal heir of the appellant, my lord, to do substitution and all, my lord, but they are not turning up on the one hand. And secondly, they are saying, my lord, that the matter has been compromised before the date of his their mother, my lord. Of course, right now I can make any comment on the same, my lord.
Close it by granting liberty to set aside
My lord.
appellant. Mr. M.S. Chaudhary, senior counsel for the appellant, submits that the sole appellant in this case has died on 16/9/2019, but despite his repeated effort, the names and particulars of the legal heirs could not be obtained for filing substitution application. Be that as it may, if the appellant had died on 16/9/2019, the appeal has apparently abated by operation of law. In view of the above, and as agreed to by the appellant's counsel, this matter stands closed as having abated by granting liberty to the appellant to file appropriate application for setting aside abatement of the appeal and for substitution of legal errors of the appellant, along with a prayer for delay condonation at an appropriate time. No, a delay condonation, fixed or advised. Register to send back the answer.
May it please your lordship.
Yes.
Your lordship, I am for the appellant. This is a suit for eviction suit and the decree has been executed. So presently the appellant doesn't want to pursue the matter. I have instructions to withdraw.
Decree has been executed.
It's a bit of long backward.
What do you say? You are for the
I am
plaintiff,
for a respondent. Thank you.
respondent plaintiff. All right. You take job. Heard Mr.
G.R. Datta.
G.R. Datta, learned counsel appearing for the appellant. Also heard Mr. P.P. Datta, learned counsel appearing for the respondent. Good stuff. The defendant. Where is the RSA? What is this case about?
There are several mistakes. One for striking out the name of respondent,
Give me the main RSA.
one for substitution of legal error, one for abatement of substitution of chief.
Order will be passed in the RSA. Huh? This appeal is directed against this appeal referred by the defendants in title suit number
Title suit number 50/1993.
50/1993,
That's it.
instituted in the Court of Civil Judge, Senior Division, Jorhat, is directed against the judgment dated 11/9/2002, decreeing the suit for eviction of the defendants appellants from the suit land. First of all, Mr. Datta submits that during the pendency of the appeal, the decree has already been executed and his clients have been evicted from the suit land. First of all, as such, nothing survives for adjudication in this appeal. The aforesaid factual position has also been confirmed by Mr. P.P. Datta and counsel for the respondent. In view of the above, this appeal has apparently become infructuous. Mr. Therefore, with the consent of learned counsel for both the sides, this second appeal stands disposed of as infructuous. Then this case stands disposed of in view of the order.
It was by Munship number 1.
Huh?
Munship number 1, not civil.
Achha, 50/93 in the court of Munship number 1.
Sir.
At Dubai.
Obliged. Your Lordship.
May it please your lordship. On earlier occasion, as per order dated 22/8/22, our learned counsel for the respondent, they are supposed to help us for collecting the name of the legal heirs of the deceased appellant minor, which we have not yet received.
Yeah, I tried to contact my client, my lord. The phone number isn't working, my lord. I have not established my contact with my client. Then my appellant died on 25/12/19, my lord.
In the light of order dated 22/8/2022 passed by this court, learned counsel for both the sides pray for 4 weeks further time to do the needful for obtaining the names and particulars of the legal heirs of the deceased appellant. As such, register to list the matter again after 6 weeks. To obtain the names in particular and also to file application for substitution.
With this new development, which your lordship will find earlier, I informed in connection with the other case,
Yes.
that FT matter case, that there is a contemplation of dispensing with the services of the newly appointed FT members. Now it has taken a practical shape now with the passing of the notification of 14th
What is
of
this
October.
expression forfeiture?
That is why I'm using dispensing, it should have been dispensing with it.
How can the service be forfeited?
Anyway, madam, there,
Well, this expression should be changed. This will have legal implication.
and it is further mentioned,
No,
what will-
see, the government cannot forfeit the service of tribunals appointed by the High Court.
more than that,
Then we'll have to go into this matter, legal aspect of the matter.
I will correct it.
Mm.
Will correct it.
Please tell your departmental official.
Two corrections
The
and
forfeiture will have various meanings, then everything, then the government can even take back the money paid to them.
one more correction possibly will be necessary. Here it is mentioned as appellate foreigner tribunal, it's not appellate. I'll inform you.
So please have the corrections issued. And the forfeiture appears to be an order issued with anger.
Dissatisfaction.
Yes. What do you have to say?
With this new development, possibly at this stage, no further order is necessary. Lordship will reassess the matter with this case relates to infrastructure. With the this development manner, whether there is any further infrastructure problem or not. We'll see if there is any, we'll look into it. They may point out in future. Today, Lordship will just take into consideration this, keep it on record. And then may. defer it.
Mr. Das, what do you have to say?
Lord, one aspect is there, if we consider it from Lord service jurisprudence point of view, yes, these were contractual appointments and government has every right to discontinue basing on their requirement. But if we go by the larger issue, if we go by the data of pendency of the cases, I am submitting because there are series of decisions taken by the central government as well as by the state government to reduce those numbers. As on March 31/3/2020, the pendency was 1,19,164. I am asking myself whether the pendency has reduced so much that the requirement is absolutely unnecessary of this, because government has taken a conscious decision to give them pending references.
Mr. Das, I have understood your query. This query was also made by this court to the state councils.
Lordship.
The problem is, this court has a limited mandate. This issue can either be raised in an appropriate forum, or if the Honorable Supreme Court modifies the earlier order and asks this monitoring bench to go into this, we'll go into it. If those either of the two things are not happening, there is absolutely no purpose in making these arguments. Because from the reading of the Supreme Court order, as I could understand, the monitoring bench's duty and entrustment is to see that the tribunals function without any undue hindrance. What kind of work the tribunal should do, what work the government should give them, it is none of the jurisdiction.
Absolutely correct.
of this court.
Yes,
So therefore, what is the point in going into all these things?
I have those
No, you
questions
have
in
to
my
think
mind, Milord. That's why I feel like.
So
since this
maybe
is-
if somebody gets a clarification from the Supreme Court that
Because this entire thing came up ultimately by the assurance given by the state government and central government before the apex court. 1,000 tribunal, then reduced to 400. As a pilot project, we come up with 200.
correct. So
That's-
therefore this matter will now have to be looked into by the Supreme Court.
That is,
And if the Supreme Court says, no, we relegate the matter to the High Court to examine, this
Yes.
court will do it.
true. That is absolutely correct.
The mandate has to be clearly from the Supreme Court's order.
Otherwise, we are concerned with functioning only, whether it's going correct. Yeah. That's true.
So something which is not to be decided should not be decided.
Absolutely.
Something which is not to be argued should not be argued in this court. This is the
I-
fundamental principle.
I am having some questions in my mind. That's why I feel like.
Hold it back. They will have the answers before you finish your questions.
They already have all the answers.
That is the problem.
They already have all the answers.
Answer is
Open your cards before it is necessary.
simple, my lord. This is the mandate of this bench and this case is to monitor the existing tribunals. If the tribunals are not there, then it is for the honor Supreme Court too.
Milord, one more aspect,
Yes.
if I can, Milord. Milord, the initial approval was sent by the government of Assam to the central government was 13/9/2022. And the final approval from the central government came on 14/10/2022. In between, Milord, these members, they discharge their work. I'm not talking about their salary and Milord perks, Milord. What I'm saying is that in between, they have passed some opinion, Milord. They have given some opinion. State has to take
That's
care.
what I said. Forfeiture is not the right word. You must change this order. Otherwise, we will have to step in.
And
How can a forfeit? What happens to the orders?
And
first?
this
What happens to the
retrospectivity also.
salary? Forfeiture means it's null and void.
we'll take it.
That's a very wrong expression used. This expression, if it is not changed, then the court will have to step in.
We'll take care of it.
Then it will impinge on the question of the work done by the tribunal so
Right.
far. So therefore, I'm fixing it in the month of December. and
But in the
to obtain
meantime, we'll
instructions.
correct.
Mr. H.K. Das, Learned Amicus Curiae, appearing in this case, also heard Mr. D. Matunga, honored additional advocate general, Assam, State, and Mr. R.K. Devarajan, learned Deputy Solicitor General of India, representing the Union of India. Today, when the matter was called up, Mr. Majumdar has produced a copy of the order dated 14/10/2022, issued by the Commissioner and Secretary to the Government of Assam from a Home and Political Department, forfeiting the services of the 200 members of the Foreigners Tribunal with effect from 23/9/2022. Full stop. A similar order has been passed with regard to the ministerial staff supporting the 200 appellate foreigners tribunals. Full stop. Mr. Majumdar submits that with the issuance of the order dated 14/10/2022, there are no foreigners tribunals, the functioning of which requires to be monitored by this court, and therefore this entire process has become, this proceeding has become infructuous. Mr. Das, learned Amicus Curiae, has however opposed the said argument and submits that even the language employed in the order dated 14/10/2022 is inappropriate, and therefore the matter calls for further examination. Responding to the above, Mr. Majumdar submits that if there is any objection pertaining to the language used in the order dated 14, language stroke expression, more particularly the word within quotes forfeiture used in the order dated 14/10/2022, the matter can be revisited at an appropriate level and necessary clarification can be issued, for which some more time is required. Having heard the submission of both the sides and on the request of learned State Council, this matter is directed to be listed again on 21/12/2022. So as to enable both sides to examine the issue and address this court further as to the question of continuation of this monitoring bench. Copy of this order dated 14/10/2022.
Subject to correction.
One modification. I say that in respect of this additional, there may not be any order required, but in respect of
Under
existing tribunals, initial and original under tribunals, this honorable court may monitor matter.
Under tribunal is already
Monitoring may not be necessary insofar as
Additional tribunal.
the additional tribunals. So in fact, it's the part to you.
Okay.
All right.
Deeply.
May it please your lordship. In this, these are 454 and 468 of the Old Companies Act matters, my lord. Your lordships would recollect that since the directors could not be traced, the official liquidator had proposed for dissolution of the company, my lord. Accordingly, the matter was posted today for further instructions, my lord. My juniors have received instructions from the OL that he has proposed a meeting on 14th November 22 of the creditors, my lord, to ascertain their wishes, my lord, and so as to then proceed for dissolution. So your lordships may have these matters anytime in December, my lord. Till that, my lord, further.
Mr. K. Goswami, lawyer senior counsel appearing for the OL bracket, no, for the official liquidator bracket OL. O/L. If it was summons that as per instructions received by his junior, a meeting of the creditors have been fixed on 14/11/2022, so as to ascertain their wishes before proceeding further in the matter. And therefore, this application be taken up again after 4 weeks. Please take on.
Deeply honored.
May I please, your lordship? Lordship, this IA is for consideration of delay of 300 days in filing the substitution petition in review petition number 87 of 2015, lordship.
What has happened? Notice has gone.
No, lordship, notice is not been issued. lordship.
Substitution application, what is the case number?
Lordship, substitution we have filed.
IA number
IA number 1782. Lordship.
1782. And what is 1781?
1781 is lordship for continuation of delay. Lordship in filing the substitution.
Okay, then you will pass the order. He will issue notice at this stage.
Lordship.
All right. Heard Miss
K. Khan. K. Khan.
K. Khan,
Lordship.
counsel appearing for the applicant. His IA has been filed under section 5 of the Limitations Act, 1963, with a prayer to condone the delay of 300 days in filing the substitution petition in the connected review petition. Peruse the grounds taken in the IA, stop issue notice, returnable and fruitful. Applicant to take steps for service and notice upon the office parties as well as legal process within 2 weeks from today.
Yes.
Lordship, if I may, matter may be passed over as my senior is on legs in another matter.
Why it has been listed today?
Lordship, respondent number 2 died, lordship, so they were directed to file substitution. That was not done, lordship. And I am appearing for respondent number 1, 3, and 4.
Lordship, actually, we have not obtained the address of the legal heirs of the respondent number 2. Lordship.
I'll try, lordship.
Do you have the particulars?
No, lordship, I have to collect.
Your name, please?
G. Imtiaz appearing for Mr. G. Imtiaz.
Mr. GMT and I counsel for the appellant submits that since the names and particulars of the legal heirs of deceased respondent number 4 could not be obtained.
Respondent 2, your lordship.
Respondent number 2.
Yes, sir.
And the necessary application for substitution could not be brought on record till date. First of all, Miss R. Chaudhary, learned counsel appearing to the respondent numbers
1, 3, and 4.
1, 3, and 4 submits that although she does not represent respondent number 2, she did not represent the deceased respondent number 2. Yet, an attempt will be made to collect information about the legal heirs of deceased respondent number 2 if 4 weeks time is granted by this court for the purpose. Prayer allowed that this matter be listed again after 4 weeks. In the meantime, Ms. Chaudhary may furnish particulars of legal heirs of respondent number 2 to the appellant's counsel in writing, if the same can be obtained by her.
Highly acknowledged.
May it please your lordship. Lordship, in this matter, efforts were made to mutually settle the issue, your lordship, but the same has failed. So it may come up for admission hearing, your lordship.
Appeal has not been admitted
No.
yet. Learned counsel for both the sides submit that these appeal have not yet been admitted and therefore the matter be listed for admission under order 41 rule 11 CPC. The registrar to verify and list the matter accordingly.
Deeply obliged.
Even Roman circle.
May I please your lordship. Under this review has been filed against the judgment and order passed by this honorable court in CRP number 387/15. Mainly, basically, we have filed this review on 3 points, lordship. Regarding the first point, the honorable court, while passing the impugned judgment, has pleased to observe that the suit was not filed within 6 months, because originally the suit was under section 6 of the specific relief act. But there is a specific issue of the trial court regarding this, that suit has been filed under within 6 months of disposition.
So this matter would require some.
My lord, this review petition, lordship, you can kindly see in the, they have filed this present application, the review application of your earlier order passed by your lordship. Initially, there was a, just in 1 minute I can complete my. Initially, there was a suit for declaration of title and recovery operation filed by them. Suit was decreed, decree was executed. Subsequently, they have filed an application under section 6 of this specific act saying that they have been subsequently dispossessed. That was once decreed, then we came to High Court, Supreme Court remanded. Lastly, when there was a decree, there was a dismissal, they came before your lordship. Your lordship specifically observed that there has to be a fresh Amicable commission. Fresh Amicable commission was not done, apart from other illegalities. And your lordship has also recorded a finding in the order under review that they have to go for a regular suit. And then we filed a review of this order. Lordship, can you see just this review on there? There's nothing.
Regarding the title of the land, decree has been already passed, and against that decree, they have not filed any appeal. But that becomes the attain finality, lordship. That is the problem.
That's correct, but subsequently, if you have been dispossessed, that also brings in a cloud to the title. So that decree, earlier decree can be the basis for declaring your title once again. But you can't say that there is no need to declare title. That you can't say. It's a subsequent cause of action.
Lordship.
You examine this matter, we'll take it up next week and finish it.
Lordship.
Then a counsel for both the sides submit that this review petition can be taken up for disposal as the pleadings, anything you have to file.
No, ma'am.
As you write like this, Mr. J. Kalita.
D. Kolita.
G. Kalita, Learned Counsel for the review petitioner. Also heard Mr. D. Majumdar, Learned Senior Counsel assisted by Mr. J. Lashkar, Learned Counsel for the respondent, who submit that there is no requirement for filing affidavit in the review petition, and the matter can be disposed of at an early date on the basis of materials available on record. In view of the above and as agreed to by Learned Counsel for both the sides, let this review petition be listed again on 10/11/2022 as a fixed item.
Public.
The matter will be taken up for disposal on the next day.
May I please your lordship.
Yes.
Lordship, I have taken steps for service of notice upon respondent number 1, ma'am. Both by registered post as well as usual process, ma'am. 27/9/2022.
Service report on respondent numbers. Respondent number
1.
But the note says you have not.
Yes, notes stated that, my lord, I have not taken steps, but I have taken steps, ma'am. On 27/9.
Take down, you write it like this. Mr. T. Lashkar, Learned Counsel for the appellant submits that he has taken steps on
27/9, ma'am.
27/9/2022 for service of notice upon the respondent number 1. However, as per office note dated 23/9/2022, no steps have been taken for service of notice upon the said respondent in due. Be that as it may, in view of the submission made by Mr. Lashkar, registered to verify and list to matter after 3 weeks for further orders.
Obliged. May I please, Your Lordship? It will kindly matter maybe urgent today, Lordship, because Lanet Arguing Council dedication is out of station today, Lordship.
What is this IA?
IA for condemnation of
This is
delay.
for condemnation of delay pending from 2018.
Lordship,
And
except
the-
today, tomorrow is,
And the
today is.
decree is already executed. This is.
Monday or Tuesday, any date, Lordship, except today or tomorrow or today, any other date, finally fixed, Lordship.
On the request of applicant's counsel, let this matter be listed again as a fixed item on 9/11/2020.
Obliged.
Mr. B. Bora is present on behalf of the respondent. And they are line counsel is present.
Lordship, earlier notice has written answered, and Lozima Court has directed to take stress steps on all the respondents. Lordship, we have come notice, Lordship, today we have taken these steps for service of notice again. Today, as for Lozima Court's order dated, Lordship, 22/11/2022, we are directed to take stress steps on respondents, Lordship, but it has not come to our notice. So today we have taken these steps on all the respondents again.
Mr. S. K. Goswami, Nair counsel for the applicant submit that due to some oversight, steps could not be taken earlier for service of notice upon the respondents, but steps have been taken today by registered post ready for service of notice upon respondent numbers 1 to 5. First, office to verify and pick up the matter again with appropriate manner.
May I please, the Lordship, my lord, in this case, my lord, I did not appear in the earlier date, so I was not aware about the steps regarding steps of respondent number 5 and 8, my lord. My lord, today we will take steps, my lord. Other respondent appear.
Mr. A. Chaudhary, learned counsel for the appellants submit that due to oversight, steps could not be taken earlier for service of notice upon respondents.
Number 5 and 8.
Respondent numbers 5 and 8.
5.
Mr. Driver, assuring this court that steps will be taken during the course of the day. Mr. Chaudhary seeks leave of this court to do the needful. Mr. Prayer allowed, subject to the condition that steps for service of notice is taken by the appellant. Service of notice on respondent numbers 5 and 8 is taken by the appellant's counsel during the course of the day. The matter be processed and listed again with appropriate note.
Okay.
May I please, Your Honor? In this case, I might be allowed to take fresh steps, Your Honor. As on the last date, I was not able to submit the steps, Your Honor.
On the prayer of Planet Council for the applicant, Mr.
H. Goswami.
Goswami, time is granted till tomorrow as last chance for taking steps. Silence of notice upon the respondent, failing which consequential orders will follow.
Highly obliged, Your Honor.
Lordship, office note reflects that LCR has come in services complete, Lordship. Office note dated 14/10/2022.
You are appearing for whom?
Lordship, for respondent number 1421 Lordship.
What about the other respondents?
Others, Lordship, as per office note, service complete, Lordship.
Office note dated
14/10/2022.
$14.10.
Lordship.
What about 3?
Service.
Lordship,
kindly have a look at,
Heard Mr. L.R. Modinda, learned counsel for the appellant, also heard Ms. R. Chaudhary, learned counsel appearing for response numbers 1 co KO, bracket pro, 2 1 cho, bracket CHO, bracket points. Full stop. None is appeared for the remaining respondents. Full stop. As per office note dated 22, remaining respondent, although as per office note dated 22/9/2022, service of notice upon all the respondents is complete in this case. Full stop. Be that as it may, office to verify as to whether the remaining respondents have entered appearance by engaging counsel and list the matter thereafter for
Lordship, LCR has come, Lordship may come up for,
list the matter thereafter for necessary order so as to fix a date of hearing.
Look.
LCR has come.
Lordship.
Matter is, Lordship, in fact, Lordship ready for hearing.
Yes, but there is no
Lordship.
verification as to.
Lordship. Verification, Lordship, this matter may again be placed for orders.
Yes.
Obliged.
Like.
May I please, my lord? I am for the appellant side, my lord.
You are for the appellant. You are for
Respondent 228.
228. What about you are appearing for 7 also?
7 also. On last date, I will file a Vokalatnama on 27/9.
What about 1 and 10?
Respondent 1 is expired
They expired.
as per the survey report.
1 was expired.
One is
2
expired.
to 8 was the legal heirs of the 1, respondent number 1.
And what about 10, 11, 12 and 13?
Respondent number 9, 10, 11, AD card received. And
All right, your name please.
Azir Rajbangshi.
Sorry?
Jintu Rajbangshi.
Jitu Rajbangshi.
Jintu Rajbangshi.
Jinku Rajbangshi. Learned counsel appearing for the appellant.
Appellant.
Also heard Miss
MD Mehdi. MD Mehdi.
MB.
MD Delhi.
MD Mehdi, learned counsel appearing on behalf of the respondent numbers 2 to
2 to 8.
8. Office note dated 8/8/2022 indicates that the respondent number 1 in this case has expired and notice in connection with the appeal has been served on the respondent numbers 10, 11, 12 and 13. First of all, in view of the above, this appeal is ready. No substitution is required.
No.
First of all, in view of that, since the legal heirs of respondent numbers, this is respondent number 1 is already on record. Hence, the legal heirs are already on record. Hence, no substitution is called for in this case. So as such, this appeal is ready for hearing. The LCR has also been received.
Received.
LCR has been received. The LCR has also been received. As such, office to list this case for final hearing in due course.
May please, Lordship. My service is complete. My learned friend has appeared, my lord. For responding.
So let it be listed for admission. I had Mr. R.S. Mr. Leonard Counsel for the petitioner, also had Mr.
PK Bodler.
Bodler, Leonard Counsel, who has entered appearance on behalf of the sole respondent. Just matter is therefore ready as regards service. District office to use this case for admission after 10 days by showing the name of Leonard Counsel for both the sides. Because this
The interim order will continue. ma'am.
interim order passed earlier to continue to the next day.
Wait, your lordship, can the matter be taken at 2, my lord? SK Talukdar is on legs, my lord. Obliged.
Well, in this case, Lord, we have alleged violation of the status quo order granted by this honorable court, my lord, in the second appeal. So we are plaintiffs in the suit, my lord, and respondents. So there is an order to maintain
What
status
is
quo
this
in
IA
the.
about?
My lord,
What is this IA about?
I am about violation of the status quo, my lord.
Who has filed it?
I have filed, my lord, I have the plaintiff in respondent. in the-
Why are you standing this side? You should be that side.
There's a temporary injunction order, my lord, on passed by this honorable court on 24/1/2018, page 23 of the IA, my lord.
Who is appearing for the opposite party?
Mr. U. Dr. my lord. He has filed an objection.
But his name is not shown in the court list. Huh? It is shown.
Sold, my lord.
No, in the IA, his name is not shown.
In the RSA, it is shown, my lord. In the IA, it is not shown, my lord.
So we'll have it after a week. I had Mr. R. Chakravarti on counsel for the applicant. It appears that the name of the respondent to opposite party is not shown in the cause list against this IA. As such, registry to look into the matter and list this case again after 10 days by reflecting name of both the sides in the cause list against this IA.
May it please your lordship. Lordship, this IA was wrongly filed as the writ petition was earlier disposed of for the impediment of the parties. So we may be given the liberty to withdraw these petitions.
You want to withdraw which petition?
Both the petitions, lordship.
There are 2 IS.
Two IA lordship, one for the correction and one for the impediment lordship. So we want to withdraw both of the petitions.
The original writ petition has been disposed of.
Yes, lordship.
Item number 46 and
Only 46.
actually in 46, you write Miss A. Bora, learned counsel appearing for the applicant submit that the connected writ petitions have already been disposed of and therefore the IA has become infectious. As such, the same be closed. Mr. A. Hassan, learned counsel appearing for the respond number
Respond number 5, Accountant General.
5 and Miss
And Kalita.
and
Kalita, your lordship.
M. Kalita. For respond number
1, 3, 4, and 5.
1, 3, 4 and 5. Serially, you can cover 1, 3, 4 and 5 and so on. And so are present and do not have any objection to declare. In view of the above, these IAs to be disposed of as infrastructure. This will be in IA number 2283 and the other will be IA number 2912. Same order. Disposed of.
Obliged, lordship.
May I please your lordship,
Lordship, my senior is in some other court. Kindly pass the matter for the time being.
Second,
Obliged.
May I please, your lordship? Your lordship, in this case, what happened, I have prepared an appeal challenging an award for enhancement, your lordship. Not sure, your lordship, for dismissal. And while arraying the respondent, I have committed one mistake. In place of Oriental Insurance Company, I have made ICICI Lombard a part. So I have filed this petition under Order 1, Rule 10, Sub Rule 2 for substitution of ICICI Lombard by Oriental.
substitution. You filed it under order 1, rule 10.
Rule 10,
That is not substitution.
not substitution, your lordship.
Then what is it?
Court may strike out or add parties.
So which party you want to be added?
ICICI Lombard may be strike off and Oriental may be added.
But in the IA Oriental is a party.
No,
You have to make a party now.
on, after the court allows me to insert him as a party. Even though your lordship, so far the scheme of the act is concerned, the court should not go to all those technicalities. Court may allow my petition.
Where is it written that court should not go into technicalities? Regarding issuance of notice to the party. Where do you find it?
Your lordship, so far MSC claim cases are concerned, generally
Generally what?
generally the strict rules of CPC or Evidence Act.
So if you want to impeach someone, there is no need to issue notice.
No, notice should be issued only after he is added as a part.
Show me that rule. You can show that rule, I like accept it.
Your lordship, Order 1, Rule 10, Sub Rule 2, it says or either upon or without application of either party and on such terms as may appear to the court to be just. Order that the name of any party improperly joined, whether as plaintiff or defendant, be struck off, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the question involved in the suit be added.
No, Mr. Mondal, I will not pass any order in this case. Because you made a mistake earlier, we can understand.
Yes,
Even in the IA, you have not made
Oriental a party.
Oriental a party. We can't be so liberal. Then in that case, we can do our cases in WhatsApp.
No,
You can file, you can send a WhatsApp message and we can give our orders in WhatsApp.
your lordship,
Legal procedure cannot be so diluted. You're right. The court should not be ultra technical, but that doesn't mean the lawyers can do whatever they feel like. We have to do something in between, yeah? You filed a IA. Now you want to say that even if I have not done anything correct in the IA, then also don't look into it. How that can be, how that is possible?
your lordship, so far I understood as per my minimum knowledge, I thought that it is only after correction I have to send notice.
You're right, but in the IA, at least you should have
You
put
should
the
have-
name. I can agree with that submission, but why have you not put the name of the party in the IA?
Your lordship, then for the timing it may be possible for me.
In the prayer of Mr. Mondal, this matter is passed for this.
Oblige, your lordship.
But this IA 29P2 of 2023 is for fixing, for passing an order for fixing the matter for IA.
Yes, what is the ground?
My lord, in this case, my lord, the appellant challenged the judgment and decree dated 8/7/2014 and 18/7/2014. Passed in title appeal number 27/2000.
That is not the ground. What is the ground of early hearing?
My lord, this is the part respondent being the applicant has been agreed with the input actions of the appellant, my lord. This is the father's property and as per the, as
Those are on merit, my lord.
my lord, whether there is a merit or no merit, it will be decided after hearing this matter, my lord. Because my lord,
What is the ground for early hearing?
ground, my lord, this early hearing means this appeal is pending since 2015. So my lord, and stay also granted in this matter. So respondent is agreed with the informed decision with this pendency of this case, my lord, for a long period, my lord. He want the decision at an early date because title appeal, appellate court
Ms.
already
Chakraborty,
been
I will give you early hearing, but your application is completely non-meritorious. You have not even whispered on early hearing, any ground for early hearing. You must make your juniors understand this. This is not the way applications are filed. Petitions pending since 2015 is not a ground of early hearing. These are things which are well settled. I will give you that, but not because you made out a case.
Because the appellate court my lord passed the order in my favor,
If
my
you
lord.
oppose it, then this petition has to be.
In my favor. So after having this order in my favor, I am getting the title right over this true property, my lord. Still, I am without any property.
There are thousands of appeals like this. What to be done?
Means in Jamabandi and then Chitas of subject release, my name is there, my
File
lord.
objection, we'll hear it then.
My lord.
You want to file objection? You want to file. Yes. Heard Ms. Chakraborty, Ms. Counsel for the assistant, the IA has been filed with a prayer to grant early hearing of the connected. Mr. Peacefully submit that no ground for early hearing has been made out in the IA and therefore it will be granted 2 weeks time to file objection. Prayer allowed. If you would concede that your application is not appropriate, I would have granted the order right now. But you are arguing, so then we'll go into
Yes,
it.
my lord, as your lordship, please, my lord, I am not for objection, I am no objection. If my application is not appropriate,
Yes.
if lordship pass the necessary order, as deems fit and proper, my lord, I don't have any objection.
That's what we asked. I asked you, you went on
So it is
arguing.
my humble prayer, this case may be heard at an early date, my lord, because I want to dispose of this matter.
That's all
Whether
right.
I
but
will or not,
You have not made out any such ground in your IA. Do you agree or disagree
yes,
with
that I agree, my lord.
So it is a discretion of the court that I'm giving
Yes,
you.
my lord.
You have not earned it on merit. That's what I'm saying. Strike off that order. Heard Ms. Chakraborty, Learned Counsel for the applicant. Also heard Mr. P. Sindhu, Learned Counsel appearing for the respondent. His IA has been filed with a prayer to grant early hearing in the connected RSA. RSA which has been pending since the year 2015. Ms. Chakraborty submits that due to non-disposal of the appeal, our client has suffered immensely. First, after hearing the submission of Learned Counsel for both the sides, the prayer for early hearing is hereby allowed. Registered with this the connected RSA being RSA number so and so for being RSA number 25 of 2015 for hearing as a fixed item on. It'll be on January 2023. On. You have the calendar? 20th, 19th or 20th January, either of the 2 days. 19th or 20th January. Just give the date which is a hearing date.
Hearing date.
19th.
19 is Thursday.
19th, Thursday.
19th
19th.
January, Thursday, as a fixed item, along with the LCR.
LCR already received, my lord.
I just have this.
Much.
Can I get any liberty to file the vacation of this stay order granted by the honorable court? It's a long period, that's what I have not filed one.
Now
After
you've got the
disposal of this
hearing,
case.
19th is a fixed matter, it's coming 2 months away, you prepare and argue it.
For that, my lord, they do not require any liberty, my lord. They can file anywhere, my lord.
That's fine. Yes, yes. Well, what your order?
Bless you, Lord.
May I please, your lordship, this application, my lord, under order 22 rule 2. To struck off respondent number 2, who demised lordship. And the date certificate, your lordship, please state. This is the pending.
What is the name of respondent number 2?
Mona
Begum.
Mrs. I Mona Begum. She was the mother of the deceased. Mother of the deceased.
Any objection? No. But what about others? Respondent number 2?
Two is to be stuck off, my lord. Other respondent, my lord, 3, 4, 5, 6, 7. They are also claiming your lordship. Their name, lordship, necessary
So
correction.
notice has been served on them in the main appeal. Huh?
This is already, my lord, at the hearing stage, lordship.
No, but have they appeared in the main appeal?
Lordship appeared.
Respondent number 1, 3, 4, 5, 6,
Yes,
and
yes,
7.
yes, lordship. One last order by my lord passed on 12/8/2022. And the honorable court directed to receive the
Yeah, give me the file.
amount.
You are not answering the question, Mr. Bhura.
Lordship, I am the appellant, Lordship. Insist opinion is the appellant, Lordship. He is the
Respondent.
respondent claimant.
Claim and respond.
So you are appealing? to
Yes.
this one.
Yes, lordship.
All right.
And
Uh,
the
Miss-
hearing stage.
Miss, heard Mr. K. Bhura, learned counsel for the applicant. Also heard Mr. A. J. Saikya, learned counsel representing the insurance company. Uh, By filing this IA, a prayer has been made by the applicants, stroke respondents, for striking out the name of respondent number 2, Mrs. I. Mona Begum, on the ground that she has already expired. Mr. Bhuya submits that the other legal heirs of the deceased
They are
are
also
already on record, and therefore the name of Aymuna Begum, that is the mother of the deceased, is struck off on the record of this case. The prayer is not opposed by Mr. Saikya, learned counsel for the insurance company. In view of the above, the prayer made in the IA stands allowed. The name of Miss Aymuna Begum, Mrs. Aymuna Begum, is struck off from the array of parties in the connected appeal. Registry to make necessary endorsement with the court establishment.
I love. Obligation.
Your lordship, my senior is in late. Kindly pass over for time.
All right.
Highly obliged. Lordship, this IS is for condemnation of delay of 22 days in preferring the regular second appeal. Lordship, may issue notice.
Notice. Heard Mr. R.
D. Bora.
D. Bora, learned counsel for the applicant. His IA has been filed under section 5 of the Limitations Act 1963 with a prayer to condone the delay of 22 days in filing the connected appeal. Issue notice returnable in 6 weeks, calling upon the respondents opposite parties to show court as to why the prayer for condonation of delay should not be allowed by this court. Applicant to take steps by the instructions.
Lordship, name of this Mr. S. Count has not been reflected. Lordship, that may be.
This matter be listed again by showing the name of Mr. S. And it comes to the applicant in the file.
Obliged, Lordship.
Lordship, as per office note dated, your lordship, service upon correspondent complete your lordship in this matter. Your lordship.
So let it be listed for admission. Or Mr. K. Miralani, counsel for the petitioner, there is office note dated 28/10/2022, according to which this matter is ready as regards service. In view of the above, registry will list this case again for admission after verifying as to whether all the respondents have entered appearance by engaging their counsel. During order passed, I have to continue from there.
My lord, what has happened in this case? One of the review application is listed. Along with that review application, the other matters, my lord, are before your lordship. Those are otherwise, my lord, bench for matters. Now, what has happened? The connected petition is, my lord, the 35, item 35. They wanted, my lord, dissolution of the board. Now, by this time, the board has been dissolved. So the connected petition has become infructuous, and pursuant to the dissolution, one-man committee has also been appointed, and election is fixed, my lord. That's the matter.
If he says so, my lord, that this order has been issued, then nothing would remain.
I think your lordship will make it part of the records, my lord.
Let him have a look. Let him have a look. One modification of order dated
29/6
29/6.
at page 18.
In the 31.
31 is the operative part, and it starts.
So now what has happened? Another, again, a one-man committee has been.
Yes, in fact, my lord, what has happened? There, my lord, the board in that case failed to hold the AGM. due to the COVID. Now pursuant to exemption granted, my lord, the board held the AGM. That was, which was lapsed, my lord. And pursuant to holding of the AGM, they came before this honorable court, saying that the interim order will be modified. Because one-man committee was also, my lord, engaged therein. And the argument was coexistence, my lord, is not permissible. And your lordship held that since the board has again come, it is, my lord, operating, functioning, my lord. Therefore, one-man committee should be removed. Therefore, this was, my lord, the interim order was passed, my lord.
Then now this 2nd September, one-man committee has been appointed by removing the board.
Board, my lord, earlier board, it continued for 17. My lord, since the 5 years term had expired, my lord. So by virtue of some interim orders, board was continuing. Then, my lord, the board itself came before your lordship, saying that since the 5 years term has expired, the lordship need to pass a direction for appointing one-man committee and for allowing to hold the election, my lord. Then in that case, my lord, 5269 WBC order dated 190. In that, my lord, the government order, only the date is mentioned. WPC is 5629. 5269 order is 19. In that case, lordship say that dissolve the board and hold the election. And pursuant to your lordship's order, this order is passed by the register.
Then we'll close it. Heard Mr. S. Banik, learned counsel appearing for the review petitioner. Also heard Mr. S. K. Talukdar, learned standing counsel corporation department appearing for the official respondent. By filing the review petition, a prayer has been made. People of the order dated 29/6/2022 passed by this court in WPC number 244 and others. IA, beginning application was filed. 1898 of 2022. Out of WPC number 244 of 2022. 24 of 2022, as well as the connected petitions. Right. This court permitted elected board to look into all affairs of the Samavai Samiti Limited, including the financial affairs, which was earlier looked after by the one-man committee.
Elected in 2017, my lord. The board which was continuing.
Samavai Samiti Limited, including the financial affairs. Contending that the board, the election of the board of directors suffers from some irregularity.
Review
Why do
petition
you want this order to be modified?
for the reason that as on 29/6/2022, the 5 years period, the statutory period lapsed. 3/6/17 was the last election. So 2/5/17 would
The
be.
review petition had to be filed account of the fact that on the date of passing the order dated 29/6/2022, the 5-year term of the board, elected board, had already lapsed. And therefore, there was no scope for the board to manage the affairs of the society. First up. Today, when the review petition is called up, Mr. Talukdar has produced a copy of the order dated 2/9/2022, issued by the Journal Joint Register of Cooperative Societies, by means of which a one-man committee has been appointed to look after and manage the affairs of the society. Full stop. Mr. Talukdar submits that in view of the order dated 2/9/2022, the plea raised in the review petition is no longer relevant, as the elected board is not running the affairs of the society any further.
Also the connected petition 244.
Further. It is also the submission of Mr. Talukdar that in view of the order dated 2/9/2022, WPC number 244 of 2022 has itself become infructuous, and therefore no further order is called for in the review petition. Mr. Banik, learned counsel for the review petitioner, has also duly agreed to the said submission. In view of the above, by retaining a copy of the order dated 2/9/2022 in the record of this case, the review petition stands closed. Registered in this connected read petitions before the appropriate bench for necessary orders.
Along with 244 also, it may be closed.
244 means
244/22. 244 was for dissolution of the board, man. That prayer.
Yes, counsel in 244.
He is a principal counsel.
244 of 2022. Mr. S. Banik submits that learned counsel for the petitioner submits that in view of the appointment of one-man committee by order dated 2/9/2022 issued by the General Joint Register of Cooperative, nothing survives for adjudication in the date petition. Mr. S. Learned Standing Counsel Corporation Department Assam is present and support the said view and suppose the said submission. In view of the above, this petition stands disposed of the infractions, entering order for if any passed earlier.
Obliged.
obliged.
Lordship, we have preferred the IA Lordship 2473. They are to restrain the appellants from evicting the applicant's Lordship from the suit land Lordship. Actually, the original title suit was filed by the present appellant Lordship, which was the decree was passed in their favor. Thereafter, we preferred the appeal before the district judge Lordship and appeal also succeed Lordship. Thereafter, they filed the RSA and since 2014 Lordship, the RSA is pending. In the meantime, Lordship, in 2021, the appellants, they filed an application that we are changing the suit premises, Lordship. Then your Lordship was pleased to pass an order dated 8/2/22, which is at page 14, Lordship. It was directed the status quo as on date has to be maintained. Then Lordship, suddenly in the month of April, Lordship, some people along with some revenue officials, they entered the premises and they started to measure the premises, Lordship, which at that time, Lordship, no members of, that means the only the elders were present in the home and others, they were not there. Suddenly after coming to know this, they rushed to the home, Lordship. Then they found some officials and with some people, Lordship, they are demarcating the land and writing down something. So when they inquired, they said that no, there is order from the court. So they stated that, okay, let us see, show the order, which was not been given to us till date, Lordship. So they are just feeling, Lordship, a little bit anxious that they may be evicted at any time because they have verbally threatened also.
But there is already order of status quo. Then
after that, Lordship, they have done this.
file contempt case.
And again, 8/4/22, they themselves has done these things, Lordship.
Who has done it?
And Lordship, the present appellants, Lordship.
Your
Yes,
Lordship, I beg to differ with my learned counsel. There has never been any infringement of the status quo order, Your Lordship. We will not be touching upon their premises. Your Lordship, the surrounding areas, there are 3 plots in 3 different surrounding
File
areas.
an objection.
Yes, Your Lordship, I have filed my objection. Your Lordship.
The objection.
Huh?
In this case, you have filed the
Yes.
objection. No, I have not received any copy. No, I have not received.
It is not in the record also.
It was filed in 13/8/22.
IA 2473.
Your Lordship.
Acha, it is not in the record. Just check. You have received a copy of the objection.
I have not.
What is the date of the objection? When did you file it?
13/8/22, Lordship.
13/8.
8/20.
And we'll ask the registry to tag this.
Your lordship.
In the meantime, we'll give her a copy also.
Lordship.
You are the applicant's counsel, is it? You are the applicant's counsel. Then why are you switching sides?
Lordship.
Who was also. This I am the learning counsel for the applicant. So had Mr. H. Akil, learning counsel appearing for the respondents who submit that objection filed this case on behalf of his clients on 13/8/2022.
Correction, lordship, 23/8. 23. My apologies.
2022 is not on record.
It's eight, no?
Also
One side on them.
no copy of the objection has yet been served upon her. In view of the above, this IA cannot be taken up for disposal today. Registry to list this matter again after 10 days by tagging the objection filed by the respondents with the record of this case. In the meantime, the learned counsel for the respondent to furnish a copy of the objection in this particular within 2 days. Just
Lordship.
that the matter be listed accordingly. Yes.
Hello.
Along with application for continuation of delay, madam. At this stage,
Notice has to go.
at this notice.
This IA has been filed under section 5 of the Limitations Act 1963 with a prayer respondent to delay. Delay of how many days?
My lord, around it is around 10 years, my lord.
10 years.
My lord,
Delay of
4,037 days.
4,030, within 3,322 years.
Yeah, no, there may be some calculation actually work out in it.
Delay of about 3,322 days in filing the connected division petition. I heard Mr. S. Sharma, S. Sharma, and I counsel for the applicant. Also present the grounds taken in the petition. Issue notice returnable in 8 weeks. Applicant takes steps for solution.
Yes.
May I please, my lord, I shall make submission, my lord. This matter will be adjourned only for today, my lord. I shall make my submission tomorrow, my lord. Item 1.
Okay.